All right. Hello and welcome to Policies for Reopening and Remote Workforces, which is the title of this webinar. But what it's really intended to be is the legal version of Between Two Ferns. For the next 45 minutes or so, and then we're going to open up to Q&A. We are going to talk about how to reopen safely during COVID, which is as a situation, as you all know, that is very much in flux. When we first came up with the abstract of this webinar, the curve was flattening across the country, and now that's no longer true, and it varies depending on where you live and what your local government's particular policies have been. And so I want to start out with a couple of caveats. First, there's a sliding scale on everything that we say today, except for the stuff that is hard black letter law. And second, whatever you hear today and whatever you think of it, it's not legal advice. And it is not and should not be construed as such. We cannot give you, neither I nor our presenter today can give anyone advice about their particular situation. And so we would ask that, we can address to some degree hypotheticals, but we cannot provide legal advice. And there are going to be three questions that we're going to focus on thematically in the course of our conversation. The first is, what are the key employer considerations on reopening safely? The second is, what legal considerations surround transitioning to a remote workforce, as many of us have? And third, how does the CARES Act treat extended leave? And what does that mean for my business? And I'm really, really happy to introduce our presenter today, Karen Vladeck, who is an expert in employment law, and that's great. But the other talent that she has is she is capable of putting concepts in plain English so that ordinary non-employment lawyers and business people can understand them. Karen is a partner at Wittliff, where she represents corporate startups and nonprofit clients in the resolution of disputes in front of the EEOC, state employment agencies, and state and federal courts. She deals with issues under Title VII, the ADEA, the ADA, the Pregnancy Discrimination Act, the Fair Labor Standards Act, and the False Claims Act, and a variety of other statutes that consist of alphabet soup. She began as a law clerk for Chief Judge Mary Ellen Barbara of the Court of Appeals of Maryland, practiced at Arent Fox in DC before moving to Texas in 2016, and has been named as a Thomson Reuters Super Lawyers Rising Star in DC from 2014 and 15, and Texas from 2017 to 2020. She lives in Austin with her husband, Steve, and their two daughters. And I would encourage you all to follow her on Twitter at KSVESQ. All right, so with that introduction, Karen, thank you for doing this. And let's start just with our first sort of theme, and that is, what are the key employer considerations around reopening safely? And so let's start with, if you're thinking about reopening, what duties do you owe your employees in an office environment?
So you really owe your employees the duty to keep them safe. And that is recognized under both the federal law of OSHA, which is under the Occupational Self and Safety Health Act, that requires that an employer provide a safe and, in this case, virus-free workplace to the extent possible to its employees. You also have a workers' compensation system, likely in your state, that governs how employees are made whole if they're, hurt in the workplace. And so those are the two sort of governing flagpoles that you have when you reopen in this sort of situation where there are unsafeties, things that could go wrong with your employees. And I think we'll talk about this a little bit later, but there's been a lot of buzz about whether or not you can get employees to sign waivers. And we'll talk about that. But remember that there are, there's laws that protect employees in the workplace, regardless of whether it's because of COVID or because they fall and break their leg. And so, you owe your employees those safeties, and you also owe them not to be grossly negligent. And we'll get into what gross negligence means.
So when you mentioned this OSHA obligation, does that apply to everyone? Is there a threshold? In other words, can you be too small for it to apply?
You can be too small. It applies to employers with more than 10 employees. But your workers' comp structure, at least in Texas, so I'm in Texas, applies to any employer with more than 2 employees. And you can self-insure if you're fewer than 5 employees, and that's typical in a lot of states. But most states require that employers have their own workers' comp insurance that covers any on-the-job injuries. And you actually want that. Workers' compensation and that whole entire scheme is designed to protect the employer, because otherwise your employee could sue you directly for injuries that take place on the job. What the workers' compensation system does is it takes that general lawsuit structure out of the employee-employer relationship. And so if you're a person who walks into a Macy's and trips and falls, you sue Macy's directly. If you're an employee of Macy's and you trip and fall while on the job, your only way to collect damages is through the workers' compensation structure, except in the instances of gross negligence, and we'll get to that. And so, as you can see, that's a great protection for the employer, because they're not opening themselves up to direct liability. The only thing that the employee can then recover is through the workers' comp system, through that insurance process.
So what kind of basic steps can an employer take to minimize risk? I mean, obviously the situation is fluid. Realistically, as people open up, there are employees who are going to get sick.
Yes, there are. And I mean, I'm fielding calls all day about employers with different situations, employees sick and they were in the workforce and those types of things. So as Chris said in the beginning, this is not a one-size-fits-all approach. There are different, locality issues going on here. There are state issues going on here. I would say the first thing that you can do is, follow all your state and local guidelines, obviously. So for example, if you're in a place like Los Angeles County, there is a 5-page single-space guideline on what employers need to do in order to reopen. It's very, very specific on the health and safety measures that employers need to be taking into account. The more rural areas, maybe that's not something that your locality is enforcing or your state is enforcing. What I'm instructing employers to do, and I think that this is a bare minimum, regardless of where you are, is masks are required inside at all times. The only exception to that is employees who are able to be 100% within their own office, four walls with a door closed. Any open office space, even if it has cubicles with 6 feet on the side. We've all seen that study about how this virus travels, which is in the air particles. And so, I'm sure many people on this call have seen the study of the call center where, the particles were flying over the 6 feet walls. It's just not safe to have employees in without masks. So that's the first thing I would say. The second thing that I would say is that you want to make sure that employees have access to the masks. And so whether that's, supplying disposable N95s, which is something that a lot of employers are doing because they're a little bit more comfortable than the cloth masks. That's important. Having hand sanitation areas, and making sure that employees are well aware of all these procedures, making sure desks are placed 6 feet apart. Many employers that have a number of employees are having shift work. And so you'll have all A employees are in, 1 week, and then all B employees are in the next week. So creating pods for your employees where you're able to space 6 feet apart if you have more of an open concept workplace. Those are all sort of that to me is the basic that you need to be doing right now. And things going above and beyond that are really voluntary, but I would say that those 4 things are things that absolutely need to be supplied right now to your employees.
And so in terms of, in terms of papering it, I know you just mentioned that the waiver, there's a problem with waivers.
Yeah.
And beyond that, are there any documents that would be helpful to the employer in this kind of circumstance?
Yeah, so what I'm recommending to employees is that instead of having a waiver, and I'll get to why those are not enforceable, is that you have a return to work plan that employees are required to sign and understand that they're going to abide by those rules. And that will protect you in the instance that somebody unfortunately can prove that they contracted COVID at the workplace, and B, that they died from it. So for example, in Texas, if an employee dies in the workplace and there is a gross negligence standard, the employee can then go outside of the workers' compensation system. But you have to show gross negligence. Gross negligence is a very, very high standard where you basically have a complete reckless disregard for safety. So that's why when I say those 4 steps, that's kind of your basic, let's not get sued if somebody dies. And also we want to protect our employees. We're more productive if employees can come into work, right? We want people to be healthy and safe. These are things that we should want to be doing for our employees. So in terms of just making sure that people aren't getting sick, that's kind of the basic. And then the return to work plan shows employees exactly what they need to be doing. So the return to work plan will put forth all the things that they should be doing at home too, which is practice social distancing to the extent possible, taking their temperature every morning. Recent OSHA regulations have come out to say that, and this probably doesn't apply to anybody on this call, but if you do require that an employee send in their temperature, and that record is somehow maintained by a health professional. So if you have a nurse on staff or something like that, and the nurse is maintaining those health records, those are OSHA health records that must be maintained for 30 years. So I am not recommending to employers that some sort of health professional maintain these temperature checks. However, I think it's good for an HR person to be, if you have a number of employees who are coming in on a given day, they send a temperature that you can even require that they send a picture of the thermometer. They send that into the HR person. The HR person is keeping, a track of who's taking temperature and making sure that everybody's under 100. And so then employees are aware of that. So that's what I mean by the return to work plan. And the return to work plan is very specified to your particular industry. Every client of mine who's making one, they look different. If I have a daycare, that's going to look very, very different in terms of protocol than a white collar office space. It's going to be reopened, and it's going to look very different than a manufacturing floor. And so when Chris says that it needs to be specified to your industry, this is one of those that really does need to be tailored specifically to what your office environment looks like.
Okay. Well, the reality we're living in now, in a shameless segue to our second theme, is that a lot of organizations, including ours, have transitioned. Partly, we're kind of opening up in DC for now, or more fully transitioning to a remote workforce. So if you're going in that direction, let's start with the easy stuff first, which is what are the key kind of legal things that folks ought to think about when they're moving people from going into the office to going into the portions of their homes where they're not being monitored or they're not checking in.
Yeah, so the first thing that I see that falls by the wayside is for non-exempt employees. So this is employees who don't qualify for one of the Fair Labor Standard Act exemptions, and they are paid overtime over 40 hours a week. And one common misconception is that everybody who's on a salary is automatically exempt. That is not true. If this is the first time you're hearing that, email me and we'll get you guys worked out. But you need to understand that there are certain people who receive overtime for 40 hours a week, and there are certain people who don't receive overtime for 40 hours a week. And the way that they are paid, whether that's by a salary or by the hour, does not matter. So for people who are non-exempt, meaning that over 40 hours a week, they are entitled to overtime, meaning time and a half of their wages. The first thing that falls by the wayside is the timekeeping requirement. So if you have a biometric system in your office, or you have a login system in your office that employees who are non-exempt are logging in and out, when people go remote, they don't do that. And what happens in that instance is that if 2 years from now, the employee comes back and says, when we were remote for COVID, I was forced to work 60 hours a week every week and I didn't get time and a half, the onus actually falls on the employer to prove the negative. If it falls on the employer to prove, no, that person didn't work 60 hours a week, they only worked 40 hours a week. And I will tell you that the number one thing you do not want to be doing is going back 2 years to try to recreate when somebody was logged in, sending emails, those types of things. Okay, so that means people who are non-exempt are going to be keeping track of their time. I would also even recommend even exempt people keep track of their time in the event that you have a misclassification issue down the road. If somebody's on the line about whether or not they're exempt or non-exempt, and you're later on audited by the DOL, and is oh, that person actually should have been non-exempt, how many hours a week did they work, and you have no time records, it's problematic. So that's just a little warning about wage and hour requirements. The other thing that I would do is I would make it clear to employees what the expectations are for when they're working. Some employers don't care. You know, if I have an associate in my law firm and she is getting her work done by working 1 in the morning till 9 a.m. and then has to sleep all day because she and her husband have opposite schedules, I don't probably care because she's getting her work done. That may not work for a marketing company where the clients need to be interacting between 8 in the morning and 5 in the afternoon. And so I would make it very clear what the expectations are. Employers get themselves into trouble when employees don't clearly understand what the expectations are. And that's not a legal thing, that's just a managing people thing. And so to the extent that you can tell people you're expected to be at your computer between 8 and 5. If you need to take time off, that's what PTO is for. Or you have a different kind of workplace that says, you're fine, you work whenever you want, we can get stuff done. And I would just be very, very clear because employees are struggling in this 100% remote environment. And I think if they can understand exactly what you're expecting as the heads of your organizations, then everybody will be happier and things will work a lot more smoothly, and hopefully you'll be productive and financially viable.
Okay, so all right, so now you've got this workforce, and so now you have this hybrid. Probably most of us are going to have a hybrid workforce of one kind or another for the foreseeable future.
Yeah.
What as an employer are you allowed to do from a monitoring perspective in terms of whether people are working? I mean, yeah, you can have them log in, but what else are you allowed to do?
Sure. So there's expectations of privacies in the workplace. However, those can all be mitigated by what's in your employee handbook. So your policies can say, we monitor every keystroke that you take, and that is completely fine. And that is fine whether you're doing it from home or whether you're doing it from the office. And this goes into, we'll talk about this in a minute about cybersecurity, but one of the things, especially for white collar companies, if you have a Citrix type system that completely separates out the work from the home, it's easier to monitor. I think what you need to tell employees is that, if we're not able to discern the difference between those two things and you're using a company computer, right? So that's key. It has to be on the company, it has to be the company's equipment. You don't really have the right to monitor an employee's private equipment unless they're doing work, right? So unless they're using their own home computer to log into Outlook or log into their other systems, you want employees to understand that things could be, we can see what you're doing. So don't download something completely inappropriate. It's the same rules as though they were in the workplace, right? You wouldn't want somebody to be doing something completely inappropriate on their work computer in the workplace. And if employees have to work from home, you need to provide them with the equipment for that. So if an employee who is, and that's not necessarily legal, but and it can be required under California law, and we'll get there in a second, but if you have an assistant who maybe in the workplace has her own desktop and own computer, if you want her to be able to work from home, you should be supplying her with a laptop. And that's really from a cybersecurity and monitoring standpoint. It's much easier to monitor somebody's actions on the internet or anywhere else if they're working from your own equipment.
And so suppose for whatever reason you have employees using their home computers and they use that, they get sent a work email that's a phishing attack, which is of course the nightmare. Is that for everybody? Is that something the employer is responsible for? Or is that something that is that theirs, or is that something that's still sort of being fleshed out?
Well, I'm not 100% sure what you mean by responsible for, but I would say that if you're allowing your employees to access their systems from their own personal computers, that's the employer's fault. So if you log on to email from any old website and, then the employee downloads something that somehow hacks their own home computer, I would say, yeah, you should be helping the employee work that out because they were accessing it from their own personal home device.
Right.
So that I would say yes, that, I don't know if legally it's the requirements, but it's certainly from a cybersecurity perspective, you don't want whatever, that just got onto the home computer, because frankly, if they're checking their email on their home computer, they probably have company documents on their home computers too.
Right.
So it's not a good idea to just turn a blind eye and say, oh, that's your own computer. If it's gone through the company email system, the company should be addressing it.
So what about situations where, let's say you have somebody, and I'm making this up, so I don't even know if this is a real hypo, but suppose you had a back condition that required you to stand up, for several hours a day to alleviate pain, and you had a standing desk at work, but you needed one for the house. Let's assume further that, the Americans with Disabilities Act covered you. Is that something that the employer is required to provide in the home?
Yeah, so the EEOC has told us whatever your normal ADA undue burden requirements are that you have in the workplace, they extend if you're requiring your employees to work from home. And this is a very important distinction. So there's a difference between requiring employees to work from home versus allowing them to work from home as a benefit. We're in a situation now where employers are requiring employees to work from home. You should treat that as an extension of the workplace. If you're requiring an employee to work from home and they have some sort of accommodation that is a physical accommodation that's in the workplace, you would do the same undue burden analysis of whether you need to do that in their home. So I think that we could look at a situation where an employee who's in a wheelchair and your physical space in the workplace accommodates them. If they came to you and said, I need my whole house redone and I need ramps and all this, you would say, well, that's an undue burden to us. And it was probably like that before. That's not really tied to the workplace, right? But if you had an employee who had a standing desk at work and then didn't have a standing desk at home because they had never been required to work at home before, I would say that the Department of Labor would definitely look at that as something that's probably a low cost burden to the employer. But you would do the traditional undue burden analysis, which is, can you provide the accommodation? Can the employee do their job with the accommodation without it causing an undue burden to the employer?
And then, okay, so just to follow up on what you said, but if you're allowing people to work from home, the rule is different.
Yeah, so the Department of Labor has said that, you don't need to necessarily, now, whether this is the right thing to do or not, we can talk about that. I'm just talking about from a legal perspective. There are lower thresholds for when you're giving an accommodation for an employee to work from home as a benefit, right? Now, I would say that right now, probably you should just make these accommodations. If somebody's asking for it and says, it's, my eyesight is so bad, if I don't have 2 monitors, I really need 2 monitors. And we'll get to this at the end, but I just am imploring on my clients to the extent possible, and I know that there's a lot of financial issues right now, so I'm not putting that aside and I'm not minimizing that. But to the extent possible that you can provide flexibility to your employees, you're going to have more productive employees. And being productive right now is a concern for a lot of employers. And so if an employee is telling you, I can be significantly more productive, I think, with 2 monitors, that's likely something that's going to pay for itself, whether or not you're going to go through the process of doing the ADA analysis. Now, if you have 200 employees who are working at home, and this is all of a sudden going to trigger 200 employees asking for dual monitors, then it's probably worth going through the process of understanding whether or not you really need to require that for people, what the threshold we're going to require for people to present to the employer to get this kind of accommodation. And it's not just going to be, okay, everybody gets 2 monitors, and then you're looking at, a $500,000 tab.
Right. And so you had mentioned before that there was a special wrinkle for California.
Yes. Yeah. So for any California employees on the phone, or for any non-California employees where there are employees that are situated in California, you have a different requirement. So California law automatically requires that employees are reimbursed for any reasonable business expense. And that includes a cell phone that is required for work. So even if you had an employee who before COVID was required to take calls on nights and weekends, employers had to cover a reasonable percentage of the employee's cell phone bill, even if the employee would have had a cell phone anyway. If they're required to have any sort of work on there, then that would be covered. And so the most recent kind of hot button issue in California is home internet required by that. The way that I've been advising clients is that the most conservative approach is to agree to have a form with the employee. There's a California form for this that designates exactly how much of the internet you're going to cover for each employee and the reasonable basis as to why you've calculated it at that rate, and have the employees sign that document so that they understand what's being reimbursed. A court has not ruled on this, but this is reading between the lines on what the courts have said about cell phones. And as you can imagine, this is brand new. We don't have any case law on this issue, but this is, I would say, the most conservative approach would be to cover a portion of it if an employee is required to be online for their job, which almost all remote employees are. And to also consider the same for cell phones, which maybe they didn't have to use a cell phone before, but now are being required to use their cell phone as their primary phone for their job. Now, if the employee can make phone calls through the phone, so you have a Ring Central or some sort of other provider or Zoom or whatever your Teams, whatever you're using, and they don't need to physically pick up their cell phones to make the call, you don't need to cover cell phone usage as part of the reimbursement scheme.
Huh. So, all right. So let me be sure I understand that. So in other words, if you provided well, you'd still need to pay for their internet, but if you provided,
you probably need to pay for a portion of the internet, not all of it, but a portion.
Right. But if you provided them with Zoom and they could do their job with Zoom, then you don't need to pay for their cell phones, or it's a different risk calculation.
Exactly. So I have a client that does IT customer service. So their employees are actually on the phone all day, but the phone runs through their computer. It's a voice over IP, and so they don't ever need to use cell phones, and so there's no reimbursement for the cell phone. But there may be reimbursement for the internet because everything that they're doing in their home for the work is coming through the internet. And even though the employee already had an internet plan before COVID, California says it doesn't matter. That doesn't excuse the employer for compensating for the reasonable portion that they're using for work now.
And that applies to, just one more question just to clarify, and that applies to employees that are located in California.
That's
right?
correct.
Not employers that are located in California. So if you have a remote person in California, you have to pay attention to this.
Yes, although the person has to actually have residence in California. So it's not somebody who has decided COVID, I'm going to go stay at my parents' house in California, and that's where I'm going to be working from. That person wouldn't be covered. It's actually somebody who lives in California, California resident.
Got it. Okay, and so I'm now going to shamelessly segue into our third topic, which is, in light of the pandemic, Congress passed the CARES Act, which changed the way that employers and employees deal with leave, so they can deal with deal with illnesses and to keep people safe. So let's set the baseline first, I guess, is probably the best thing to do. Pre-COVID, before businesses had all these trouble and people were getting sick, what were the employer's general obligations to people that it might have to lay off or who became ill on the job? In just broad brush, what are the sort of big legal risks in that scenario?
Yeah, so your big legal risks if somebody gets sick is obviously FMLA protection and then protection under the ADA. That could be
FMLA is wage and hour. Right?
The FMLA is the Medical Leave Act. FLSA is the Fair Labor Standards Act. I'm sorry.
So
Family and Medical Leave Act, which is for an employer who has more than 50 employees within a 50-mile radius. So if you have, and again, it's kind of an outstanding question about if you have 100% remote workforce, but I would just say if you have more than 50 employees, assume that FMLA probably applies to you.
Okay.
There's a California version, and I think that the threshold is 20 employees. So, and that's throughout the state of California. So FMLA essentially is an unpaid leave protection. If an employee has to take off for their own illnesses or to care for somebody else in their immediate family's illness. That is unpaid leave, however. What CARES does, and we'll get to this, is it creates a family leave that can be paid. And we'll get to that in 1 second. And then the ADA requires, job accommodations, and that could be a leave accommodation if somebody were to become sick with an ADA covered illness. COVID itself is not an ADA covered illness, but the illnesses that it's very confusing. It's like pregnancy itself is not covered by the ADA, but if you have gestational diabetes, that is covered by the ADA, even though it's not, even though we're really dancing on head of a pin here. So if it's an employee has COVID, that may not be covered by the ADA, but if they have to be, you know, go to breathing therapy or their lungs are permanently scarred or something like that, that would be covered by the ADA.
Right.
So,
because there could be results of the illness that interfere with your ability to do day-to-day stuff, which that was my general understanding of sort of what the standard is to trigger the accommodation obligation.
That's exactly right. Yes, that's exactly right. So those were kind of your only general, and then whatever your state requires. But at the federal level, that was kind of what guided you if you had an employee who was sick and had to miss significant amounts of work. Those were the job protections in place for the employee. And the ADA applies to all employers if they have more than 15 employees, regardless of where the employees are. So even if you're not covered by the FMLA, the odds are that you're probably covered by the ADA.
Okay. And so the CARES Act comes.
Yes.
And then how did it change the landscape?
Sure. So CARES is the first act of its kind ever at the federal level that requires a paid sick leave for all employers in the country with 500 or fewer employees. It really is the first of its kind. We've never had a paid sick leave at the national level before. We've had paid sick leave at local and municipal levels, or excuse me, state and municipal levels, but we've never had it at the national level. And it's very specific. It's only for COVID. It's not for COVID related. It's not for you know, anything that somebody else is sick for during the time of COVID. It is solely for COVID. And I don't know if you want me to get into the specifics of it, but it really did change the landscape in terms of what employees can take off for because of COVID and the repercussions of COVID.
Right. So, I mean, I think it might be easier to run through that in the context of a hypothetical.
Yeah, sure.
So let's suppose, all right, you know, for the moment you think you're clear, so you rehire and reopen. And then it turns out that's wrong. And your state's subject to a shutdown order because of a spike in case numbers. And there are people who are getting sick and have to take off leave for an emergency or another. How does the CARES Act, what does the CARES Act require you to do in that circumstance?
Okay, so that is a little bit different than if you're open. If you're closed because of a quarantine, CARES is not going to cover you.
Okay.
You might have a PPP and that's the loan forgiveness type
Right.
stuff to apply for that. But CARES applies to employees who are regularly scheduled to work, but because either they or a child in their immediate household has contracted COVID or has symptoms of COVID and is seeking a medical diagnosis, then you would be entitled to the 80 hours of sick leave. If you are not scheduled to work, your employer is closed, you would not get the sick leave, even if it's subject to a quarantine.
And when you say closed, that doesn't count if you're working, remote work doesn't count. Like your physical premise can be closed and you're still working. Are you open then under the?
You're open.
Yeah, okay.
I'm working from home and I'm unable to do my job because I have COVID symptoms.
Right.
Medical diagnosis, that's when I would take the 80 hours of leave.
Okay. And then are there, do part-time employees get these benefits too?
Yeah, part-time employees are eligible, but it's prorated time. So the 80 hours assumes a full-time person for 2 weeks. So if somebody was scheduled to work 40 hours, they would get 40 hours would be the maximum. The thing that's important about this is that you have to actually be scheduled to work. And this has come up a lot because you have employees who may be furloughed, and so they're not scheduled to work, and they're coming to the employer saying, I'm sick, I want to take 2 weeks of paid leave. And generally the consensus is that person's not eligible because they were never scheduled to work. They weren't actually on the schedule. And so Chris, that goes to your first question about if an office is completely shut down, operations are shut down, you own a restaurant, right? And no one's there, right. And an employee off gets sick, they're not eligible for the leave because they wouldn't have been scheduled to work anyway.
Okay. And then so can they, now that folks have this 2 weeks of leave available, suppose they don't use it, is it available to them next year?
No, it's only through 2020 right now. Now, the way things are going, this may be extended into 2021, but the leave right now under CARES is through December 31, 2020.
Okay, and then how does this interface with existing sick leave policies?
So if your company has a sick leave policy, CARES specifically says that you can't reduce your own sick leave and you can't force an employee to take it concurrently, meaning you can't say to the employee, okay, you're eligible for the 2 weeks, but you're eating up your own paid sick leave at the same time. The reason for that, and I'll get to this later on, but the paid sick leave under CARES is reimbursable as a tax credit when you file your 2020 taxes. And so the federal government is paying for this employee to go out on sick leave. And so if you as a company have other paid sick leave, the federal government's not going to pay for that. They're providing to employees sick leave that they wouldn't otherwise be eligible for. And there are caps to it, and we'll get to that in a minute, but you can't tell an employee, you can take 80 hours, but the first 40 of it is coming out of your paid sick leave from the company. And the reason that you don't want to do that too is that if they take sick leave under CARES, that is a tax credit. If they take sick leave under your own company policy, no one's paying you back for that. So you're actually better off telling the employee, take your CARES sick leave. And then if you get sick for something else later on in the year, where you are really, really sick from coronavirus and you're out for more than 2 weeks, then take the company sick leave.
Okay, and I would assume that since they're still your employee, they're just on leave, that you're required to keep providing health insurance to them if you provide it.
They're employed in the same way. They're still eligible for the maximum if depending on how much they make, they would receive two-thirds if they're caring for a child, and then up to $511 per day for self-care. So, if they make that much money, then they would be entitled to that and to the max. So you're going to keep paying those wages.
Right. And then, okay, so we talked probably before this call, in fact, who do these provisions apply to? Is there a cap?
Yeah, so the cap is to 500 or fewer employees, and then there is a small business exemption. And the small business exemption, we don't have a ton of information on it, but it's generally applies to employers with 50 or fewer employees. And you basically have to show a likelihood of a significant financial burden by giving employees this leave. I will say that the requirements for the leave are so incredibly specific. It is not an employee who is not feeling good. It's for an employee who has COVID symptoms and is seeking a medical diagnosis. So that's the big key here. It cannot just be somebody who's sick. It has to be somebody who actually has coronavirus. Now, there is a way to read the statute that also is people who have been directly exposed to it and are subject to a state quarantine. But I would say that it's generally coming up with people who actually have coronavirus. And despite the numbers being so crazy, it's still a relatively low percentage of the population. But if you do truly have a small business exemption, there are ways to avoid this. Now, again, if you want to keep your employees there and you want to use this, it's supposed to be a benefit to you. People are saying 2 weeks paid leave. That's crazy. I'm not going to pay somebody 2 weeks paid leave. Well, if you expect to still be around for all of 2020, you're going to get a tax credit on this. And so you want to give the employee that paid time off because you're just going to get that back. Now, if you're in a position where you are genuinely concerned that you're not going to make it to December 31st, 2020, if you have to pay somebody 2 weeks of paid sick leave, then that's where the exemption comes in. And that's what the protection is supposed to protect.
Got it. And is this for the employees only, or what happens? Suppose instead it's, you have a child or someone else in your household or in your immediate family that you have to care for.
Yeah. So for childcare, it is 2/3 of the wages. So if you have a child, but again, children, it's so rare right now in children. And again, it has to be an actual diagnosis of COVID. It's not just they're sick. This is really meant to protect COVID diagnoses.
Okay, so what happens if the school is closed?
So that's a totally different barrel of fish or kettle of fish, however you say.
Totally different metaphor.
Totally different ball of wax. And so that is part of the Emergency Family and Medical Leave Act. There is the second part of care. So the first part we talked about was sick leave. The second part is the Emergency Family and Medical Leave Act. And so this applies to children, whether they're at a school or whether they're at a camp, as long as you are unable to find a suitable place for your child, you are eligible to up to 12 weeks of paid leave that will run through the end of 2020, and it's paid at 2/3 of your wages, and the maximum caps are $200 per day or $10,000 over the entire period of time.
Okay.
And so the reason that that's important is that there's a lot of camps that are closed, and there's nowhere for your kid to go. One thing that's very important about this, and that you need to have employees certify, and there are certification paperwork that you want to have your employees fill out. They must certify that there's no other alternative childcare. So if you have 2 stay-at-home parents, they can't both claim it. Only one parent per household can claim it, because it has to be that there truly is no other alternative, and the IRS views another parent or another caregiver as an alternative.
Huh. That is exactly the kind of thing that one would expect out of the IRS.
Yeah, and the reason that this is important is that none of my clients have ever filed for this type of tax credit. And again, this is a tax credit. So this is supposed to be a benefit to you. This is supposed to allow your employee to take paid leave,
Right.
The same way the sick leave does, and that you get reimbursed for that employee's wages during that time. And so you want to dot your I's and cross your T's when it comes to certifying that the employee really was eligible under CARES. Because you don't want to be filing your 2020 taxes and then get a ding letter back from the IRS saying, they didn't qualify for CARES, you're not eligible for the tax credit. And I 100% guarantee you that in July 2021, that's the issue that we're going to be talking about, is the fact that the government said, we're definitely getting reimbursed for this, and now people are saying, we're not getting reimbursed because we didn't do the certifications correctly.
Okay. And so, all right, how about this one? So suppose you rehire someone, right? And you reopen, let's say it was us. We reopened, we hired someone new, and it's their first week of work. Mm-hmm. Does this apply to everybody, or is there a cutoff? Because I think folks are going to have there may be people who just get hired when they reopen because their old employees have gone in a different direction. And then suddenly the employee's kids get sick. Do you have to provide 12 weeks to them under that circumstance? Let's say it's day 2.
I don't know for regular FMLA, it's a year.
Okay.
I don't know for so for regular FMLA, the employee had to be employed for 12 months.
Okay.
I know that there probably is an answer under EFMLA. I just don't know what it is.
Okay. All right. And does this one also have a 500 employers cutoff?
Yes. So this is the same situation where the 500 employer cutoff, and you also have the same small business exemption. And so you may not, have the small business exemption for somebody who's out for 2 weeks. You might well have it for someone who's going to be out for 12 weeks.
Right.
And so if you have an employee who you cannot run your business if someone's going to be out for 12 weeks, that's where the small business exemption would come in. And you would say, we can't hold your job for you for 12 weeks. We can't function. We only have 15 people here. If one person's gone, that's not going to work for us. So that's where the exemption would come in.
Got it. And then one last thing, the lawyer's favorite part of this. What's the enforcement? How does the enforcement work here? If
so it's going to be enforced by the Department of Labor, and I believe there is a private right of action under it. If the employer has more than 50 employees, you can actually sue to enforce. Okay. And I think it would be the same types of enforcement. You can't retaliate, just like somebody who takes FMLA leave, right? You can't retaliate for somebody taking FMLA leave, meaning when they're out on leave, you can't eliminate their job if there's not really a true position elimination that's going on. You can't, when they come back from the leave, lower them to a different position that pays less or fire them in retaliation for taking the leave. So that's the same protections that you would have under FMLA.
Got it. Okay, well, that brings us to the most technologically challenging portion of today's presentation, which is we came up with, I think it would be worth going, because this was a free-flowing conversation, it would be worth going over kind of some key takeaways. And I'm going to put up a slide in a second. All right, there it is. Now I can't see my mouse. Oh, sorry, apologies. All right, that's what I meant to share. Okay, so first one, I'll let Karen sum all of these up.
Yeah, so again, follow your local rules and advisories. If you live in a jurisdiction that generally tends to be a little bit more progressive, they're going to have stricter return to work policies. Obviously, whatever advisories are in place, I think that the more we can keep our employees safe, the better off everybody's going to be. Wear a mask, wash your hands, allow employees to work remotely to the extent possible.
One question, because we've seen, I mean, you know, the internet is filled with videos of people who refuse to wear their mask. If employees refuse to do that, do you have to tolerate that?
No,
okay.
You do not. The written return to work plan, again, this covers you in the event of gross negligence, and it also has your employees understanding exactly what the requirements of them are going to be when they come back to work. And so this is a document that sets forth all the procedures that the employee is required to sign. Be sure that all your employees understand what's going to be enforced to them when they're back into the office, and make sure that there's somebody actually enforcing it. It's one thing to say masks in the office, and it's another thing to, you know, allow employees not to be doing it. I also think masks, I don't, you know, I'm not here saying the masks are super comfortable. I don't want to wear a mask all day, every day either, but this is where we are right now. And so for employees who are working inside, talking with each other, they need to be wearing masks, and they should be encouraged to go outside and take breaks in a safe distance apart, you know, so that they can get a break from their mask as well. Pay careful attention to the wage and hour requirements. So again, the employer understands that they're, you know, going to be required to prove when the employee worked. So logging in, coming up with a system, using your payroll system probably has a way for you to log in and actually log employee time. So I would recommend doing that as well. For some reason, Chris, I lost the slide, so you'll have to read it to me.
Oh, okay. This is the bullet about ADA accommodations.
Okay, yeah, so accommodations. So if you're requiring that your employees are home, treat their home as though you would treat the office. So you're going to do the same undue burden analysis that you would do as though the employee was sitting within the four walls of your office, as you would do as they are sitting in their home. So you don't have to provide, you know, require equipment that is going to be an undue burden, but you do need to engage in an interactive process to determine that.
Okay, and this one is understand CARES requirements for sick leave and family leave, and be sure that any leave allowances that you have are equally applied.
Yeah, so what we just went through, it's complicated. You know, Chris asked me a question and I didn't know what the answer was, because I have to look up these requirements every day, and I'm living and breathing this. No one is expecting you to have memorized these requirements. One thing that I should add that I did not yet state is that you are required to post a CARES poster in your workplace. And so it is now one of the required DOL posters that you have to update. And so I would say if you're in a 100% remote workplace, if you have a central policies place, you should put that poster in a central policies repository on your own firm or company intranet. And again, don't try to hide this benefit from employees. If an employee is sick, you do not want that employee coming to work. The purpose.
I think that goes to the last bullet, which is show flexibility.
Yes. I guarantee you that you are better off having the employee take paid sick leave than coming in and infecting people. And so if you can tell employees about this before they become sick, especially if you have a lower educated, sort of lower wage workforce, part of what's going on in these workforces is people don't want to miss work because they want to be paid. If they understand that even if they're sick, they're still going to be paid, you're going to reduce the spread in your workplace. And that is the goal here. In order to operate, you need healthy employees. And so trying to hide benefits or hide that people can take paid sick leave off of CARES, it's being penny wise and pound foolish. It's you know, making sure that they come into work to spread an illness is not going to be productive. And again, if you have an employee who you suspect is just trying to take paid sick leave because they want a couple days off, that's not appropriate either. But if somebody is genuinely sick, they need to know that they have protection.
Okay. Well, we can now open up to questions, and we have a few in the box. And the first one is, can you use the California form for internet for other states, or is California really the only state where you need to do that?
So it's the only state that I'm familiar with. I don't know if there's other requirements in other states, but in California, it's a specific form that basically lays out exactly how an employee is going to be paid. And I think in that instance, it's presumptive that the amount is reasonable because the employee is agreeing that, yes, that's reasonable. And so it's legal protection that down the road, the employee can't turn around and say, oh, I actually should have gotten more. And because you can say, no, you agreed to that this is the reasonable amount, this is how much you're going to get reimbursed. And so you would need to do that in California. I'm not aware of any other state that currently requires it, but it's probably worth a quick search. And I can, if you have a specific state in mind, you can probably look that up pretty easily.
And then, so the question, I have another question, which is, how would workman's comp apply when employees are working from home? So suppose the standing desk comes and then it falls over and injures somebody.
Yeah. So again,
or the worker specifically.
Yeah. Workers' comp is anywhere that an employee is doing their job. So if they're injured in the course of their employment, they are covered by workers' comp. If they are injured because it's the end of the day and they're getting up, walking from the couch to the refrigerator to get a beer, they're not covered. But so again, it has to be during the course of their employment. Now, I would say that the number of remote injuries is way down. It's one of the good things about workers' comp right now is that there's actually very few claims because employees are working from their homes where there's a way reduction in risk. But it's the same analysis that you would make for an employee during the regular workday at work. If it's within the course of their employment, it's covered by workers' comp. And
so the other question that came in is, okay, so you're hiring in a virtual environment, and there are things that face-to-face just is really helpful for, including getting a sense of a person. So is it okay to hire them as a contractor on a trial basis before making them an employee? Are there any special considerations that you should look out for when you do that?
Well, we could do a whole CLE or a whole webinar on just the difference between contractor and employee. So I will give you a quick 30-second spiel on that.
Right.
There's a difference between a temp to perm employee versus a contractor to employee relationship. A contractor, an independent contractor, has a very specific legal definition under the law, and every jurisdiction requires an independent contractor be treated differently than an employee. And the reason that is that employees, are covered by benefits. They could be covered under the ACA. There's payroll taxes associated with an employee. There's unemployment taxes associated. There's workman's comp associated. And so an employee is much more expensive, right? A contractor is cheaper, but they have to actually be a contractor. And so whether the person is properly classified as a contractor is the better question than can you have them temporary then to an employee status. You can have a temp employee. You can call somebody a temp employee. I don't like that term because all employees are temporary because all employees are at will. And so unless you have a contract that says otherwise. So the idea that somebody is temporary, the way that I would like to do that is to bring somebody on and say, you're in a 90-day, this is a 90-day trial period. At the end of the 90 days, you'll have an assessment. If the assessment goes well, then you'll be on permanent. And, but the idea that somebody's a temporary employee, I don't love that lingo. And if you want to talk further about that, I can explain why. But my preference is to do something like the first 90 days is trial, and then you'll be assessed at the end of that.
So is there a difference between, let's say, is there any legal difference between an employee and an intern?
No, it's just how people call them. And interns are required to be paid. They are still subject to the same employment rules as regular employees. So if you want to call them an intern and say your internship lasts for 3 months, it's semantics. Legally,
Right.
the law doesn't view it any differently.
Okay. I think we have gone through. I would encourage folks to answer questions. We have still a few minutes left. But if there are no other ones, and I will give folks about, I'd say another 10 or 15 seconds. We're gonna stop here, and I guess we can't have applause because like just two people is weird, and we can't see what our members are doing. But thank you so much for doing this, and this was really, really excellent. There was a lot of information in here. There will be, I mean, I would encourage those of you who are on to reach out to Karen. We are going to make this available later.
I think we do have a couple questions.
Oh, here we go. Coming in.
So
Nothing like deadlines.
Yeah, somebody asked about a where can I find a sample return to work plan?
Yep.
SHRM, the Society of Human Resource Management, is a really good a resource for plans and return to work plans. I think that the yearly membership is like maybe $200. And that's definitely going to be cheaper than having a lawyer put it together. But if you have a complicated business, a complicated industry with multiple offices, you definitely want to make sure that you have a lawyer look at it, especially if you're in multiple jurisdictions. But if you just have one home office, with 20 employees, and you want to return to work plan, SHRM is a really good place to start. I like their forms a lot.
Okay, and then the final one, or close to final, is if you're planning to space queues where there are no two people near each other, do you still need to require folks to wear masks?
Well, this is something that you're going to want to look at your own locality. So, for example, Austin just passed a mask requirement for anybody indoors. If you're indoors with somebody who's outside of your family, you have to wear a mask. It doesn't matter if you're on opposite sides of the world in terms of a business. You have a 10,000 square foot room. If you're in a business and you're both in there, you have to wear a mask. So that's the requirement here. My concern, and because this is human nature, is that, and I think COVID has shown us that when you give people an inch, they're going to take a mile. And so if you say no masks are required if you guys can sit far enough apart, well, then they're walking out to lunch together, then they're running into each other in the hallway and chatting. It's not, it's just not likely that the person is going to actually stay within their cube 100%. If you are really, if your employees are having a lot of trouble with masks, you can build sort of insulated cubes that have, 4 full walls around them. And in that instance, that would be the situation where I would say that it potentially is okay to say no masks, but the person truly has to be insulated within their cube. If you're talking about a traditional cube environment, a lot of the local regulations are going to require masks, even if the people are sitting more than 6 feet apart.
And I would also say, and I'm entirely speaking for myself and definitely not as a lawyer, but if I would really be reticent to work or remain in a place that didn't require masks inside.
Yeah.
I mean, that's going to be pardon me, the daily outrage of the mail delivery has occurred.
So, and Lisa's question about if your work requires broadcasting like this, they would need to wear the mask on Zoom too. So, of course, yeah, they would need to be wearing it at all times. What I would say in those situations is if someone's going to be presenting, that they're off sort of 4-wall space, because it's very difficult. I would not want to have done this presentation with a mask on, and I'm sitting in my guest room, and so I can do that. But if you're having a situation where an employee is, so if you have private offices, Lisa, that's probably 100% fine. You can have somebody in a private 4-wall office with no mask on. What you want to implore on them, though, is that when they're walking out, anytime they're in a public space, the mask needs to go on, and that's a non-negotiable. But again, I'm a lawyer. I'm not a public health expert. I'm just repeating what I think is good practice. But if you are listening to a different expert, or you're listening to your own local jurisdiction telling you a different thing, that's up to you. I'm just telling you what, as a lawyer, I think is the best thing to do to keep your employees healthy.
All right. Well, that brings us straight up to 1. So I would invite my co-host to turn off the broadcasting, because I don't know how to do that.
And I think Chris gave you my Twitter handle at the beginning, but if you need to reach by email, it's Karen@wittliffcutter.com, 2 T's, 2 F's. And I'm pretty Googleable. Karen Vladeck. Thank you.
Thank you. Bye, everyone.